Welcome back to Morning Glory, 9:28. I'm Mike Graham with you all the way through until 10 o'clock. There's a big story coming this week on Lucy Letby. Tomorrow, there's going to be a press conference held at which some evidence is going to be presented by several people, including David Davis, MP, about why fresh doubts are being raised over the conviction of Lucy Letby. David Rose is here. He's investigations editor at Unherd. David, very good morning to you.
Good morning.
Thanks very much indeed for joining us. This is quite a development, isn't it? It's about a scientist in the USA whose apparent sort of, unbeknownst to him, I think, evidence was used to convict Lucy Letby, and he's now kind of recanted that, and he's going to come to this press conference, I believe, and explain why he doesn't think his testimony, as it was taken, should ever have been used.
Yeah, that's correct. He produced a paper some years ago. He's an eminent paediatrician and researcher in the United States. And this paper looked at the effects of what is known as air embolism. That is the injection of air into a neonatal baby's bloodstream or possibly via the stomach, which can be fatal. And the prosecution expert at her trial, the main expert, Dewey Evans, claimed that this was the method that she used to harm the babies of which she was convicted of murder and attempted murder. The researcher in question, Shoo Lee, has now assembled an international panel of experts who have gone through all the medical notes of the babies who figured in her trials. She was, of course, retried on one of attempted murder last year. And they've come to the conclusion that no crime was committed, that there is no evidence at all of foul play. Now, this builds on earlier analysis by two eminent paediatricians in the UK, one of whom I've spoken to at great length, Dr Svelena Dimitrova from a hospital in Brighton, and they have already concluded, and David Davis said this in the House of Commons some weeks ago, that there is strong evidence that doctors who went on to accuse Letby of murdering these babies had in fact done things that were clinically dangerous, basically serious clinical errors. Perhaps the most egregious case is that of a baby known as Baby O, where a doctor who, as I say, went on to accuse Lucy Letby was found, or can be seen from the child's medical notes, to have in fact stabbed this child in the liver inadvertently when he put a needle into the child's abdomen in the wrong place, and this caused severe internal bleeding, which must have been at least a contributory factor in the child's death.
Yeah, absolutely. I mean, the difficulty, I suppose, with all of this is whether or not the judicial system, as such as it is, would allow for another trial, because that seems to have been the impediment in the past. And what makes the people who are taking part in this press conference tomorrow think that that might change?
Well, can I also draw your attention to the investigation that we published on Unherd by me at the weekend, because what this shows is a major departure from the evidence that was heard at the trial. The prosecution claimed at the trial, largely on the basis of analysis by the prosecution expert Dewey Evans, that whenever a suspicious incident took place that either harmed a child or led to the child's death, Lucy Letby was on duty at that time, at the time where he deemed the suspicious incident took place. What I published in Unherd is evidence that when he first conducted an analysis and met the police over 2 days in October 2017, he identified 10 occasions when he thought suspicious occurrences had taken place, in which, in fact, it then transpired that Lucy Letby was not on duty. Now, at the trial, the prosecution presented a chart showing a row of X's. She was on duty every time a suspicious occurrence occurred. If you look at what we published in Unheard, you'll see there's, if you like, a revised list based on Evans' initial analysis, which shows 10 gaps, 10 periods when he said harmful incidents occurred where she wasn't at the hospital. And some of these are set out in some detail. The deliberate removal of a tube, a catheter going into a child's navel, and attempt to smother a child with a hand placed over her face. Well, Lucy Letby wasn't on duty at those times, so guess what? We never heard about those incidents during the trial. Now, as to your point about the difficulty of getting the Court of Appeal to reopen the case, both on the basis of the flaws we published in Unherd and on the basis of new analysis of medical notes, the great difficulty is that over a number of years, the Court of Appeal has shown itself to be very resistant to the idea of accepting evidence that the defence could, at least in theory, have adduced at trial.
Yeah.
Now, this contrasts with the position in earlier years. I've investigated a number of miscarriages of justice in the course of my career. One of them was the Tottenham Three, the case of the three men convicted of murdering PC Keith Blakelock during the Tottenham riot in 1985. Now, when that case was referred back to the Court of Appeal by the Home Secretary, in those days, there was no Criminal Cases Review Commission, the body that now does this. It had to be the Home Secretary who asked the Court of Appeal to look at a case for a subsequent occasion after a first appeal had been lost. At that appeal, one of the three, a man called Mark Braithwaite, had been convicted when evidence that was that basically suggested he was innocent could have been available, but wasn't. And so when the defence at the appeal asked for the evidence that suggested he was innocent to be adduced, the judge in charge of the case, one of the three judges, Lord Justice Farquharson, said, yes, it is right, of course, that this evidence could, in theory, have been produced at the trial. In some circumstances, or even in normal circumstances, we would therefore be resistant to the idea of hearing it now. But, he went on to say, justice requires, that was the phrase he used, justice requires that it should be admitted now. Now, I think the problem is for Lucy Letby now is that since that time, that was in 1991, the Court of Appeal has become much more resistant to the idea of allowing, if you will, a second bite at the cherry. But if ever justice requires that fresh evidence that could in theory have been adduced in her case should be adduced now, well, it's hard to come up with a stronger set of circumstances, given that she is serving 15 whole life sentences, 15 sentences of life without parole, and she's only 35 years old. So David Davis, who has been campaigning solidly on this for some months now, is convinced that eventually this case will be recognised as a miscarriage of justice and her convictions will be quashed. Possibly she'll be ordered to have a retrial, possibly she'll simply have the convictions quashed as unsafe and be set free. He fears that this may take 20 years, and I share those fears. But I do believe that if ever there is a case for the Court of Appeal showing a new flexibility and being able to hear the new medical evidence that suggests that no crimes may have been committed at all, and the fact that the prosecution case that she was present on every occasion when something untoward happened, well, this evidence needs to be heard and aired and tested. And if it stands up, then, of course, she should have her convictions quashed and be released.
Yes, absolutely right. Incredible work, David. Great to talk to you. Thank you very much indeed. David Rose, Investigations Editor at Unherd there. It is incredible, this story. I've started, again, talking to Peter Hitchens about it months and months and months and months ago. And Peter Hitchens is not one of those who thinks that she's maybe innocent, but he just thinks that there is certainly enough evidence now to retry her, given that so much of the evidence presented turns out to be incorrect.